Right. Good afternoon, everybody. It's just a little bit after 2 o'clock. Welcome to the Cornerstone Licensing Team's webinar entitled Licensing in the COVID Era. I think perhaps lots of us were hoping that this might be licensing after COVID, but doesn't look like we're any closer to that at the moment, sadly. We've got a really excellent lineup of speakers today. We reckon we're going to detain you for about an hour. Just running through who we've that's helpful. I've got a beeping horn outside my window. The team who's speaking today: Kuljit Bogle, lots of you will be familiar with, Matt Lewin, John Fitzsimons, Rowan Clapp, and we're particularly pleased that our two newest tenants, Christina Leanan and Olivia Davis, are here as well. First of all, welcome to the team, and secondly, very exciting that you're helping us with this webinar. In terms of mechanics, there's a Q&A function on Zoom. Lots of you will be familiar with that already. If you have questions, and of course we'll be delighted to try and field as many of them as we can, then if you type them in the Q&A box, which is towards the bottom of your screen, then one of the 7 or so of us will try and field them, and particularly ones of sort of general application, we'll do our best to answer those in the course of the webinar. If we can't do that and we don't get to your question, it's a really burning question, then there's an email address at the end of the slides, and feel free to pursue the questions with one or all of us afterwards. I should just say also, before handing over to the first speaker, that as many of you will know, our website, which is cornerstonebarristers.com, has a dedicated area for COVID related licensing and beyond licensing resources. There are some videos which take you through a mock hearing, although that's not particularly COVID related, and lots of really helpful resources on licensing generally and also licensing in the COVID era. So if we don't teach you everything that you need to know today, which of course we won't, please do go and have a look at our website, and you'll find lots of really helpful things there. I'm going to hand over now to Rowan Clapp and Olivia Davis, who are going to talk about al fresco licensing.
Thanks, Joe. Good afternoon, everyone. In this part of the talk, Olivia and I are going to be focusing on the licensing issues which arise from the move outdoors has become necessary due to the increased risk of infection from the coronavirus indoors. In particular, as you'll see from the pictures on screen at the top left, there's a depiction of lots of people eating and drinking on the highway. You're going to hear details of the new pavement licensing provisions. Bottom left, you'll see the now famous QR scan code, and we'll be covering some of the GDPR implications of contact tracing at licensed premises. In the middle, perhaps slightly more tenuously, you'll see a picture of Emma Thompson starring in the 2019 film Late Night, which is representative of a particular kind of license that I'm going to address you on very quickly, that for late night refreshment. Top right, a picture of the ever-loved squidgy takeaway pint, and Olivia is going to talk to you about developments in the licensing of off-sales. And finally, in the bottom right, as you'll know instantly, that picture was taken at Lord's Cricket Ground, and Olivia is going to cover the changing position or not in respect of outdoor events. So moving firstly on to contact tracing. As you're no doubt aware, businesses are required to collect contact details from customers in order to assist with the NHS track and trace system, about which I'll make absolutely no comment. This has been achieved, for example, by requesting that a customer provide information directly in advance of attending premises, or by providing a QR code available at visible points during the premises, requiring customers to sign in before they're served. Now, that information is to be retained for 21 days, and the business will be required to collect accompanying records of all staff working on premises at the same time. As you know, the collection of information for contact tracing is a legal requirement, and in the event the information is not collected, or reservations, for example, of more than 6 people are accepted, then businesses may be subject to a fine of up to £10,000. So it's very important to take the obligation to collect data seriously. Clearly, the collection of personal data by licensed premises raises obvious data protection issues, and you'll note the ICO has produced guidance on this matter, which is helpfully titled Data Protection and Contact Tracing. As a summary overview, however, there are following guiding principles should be applied. Firstly, the business should only collect personal data which is necessary for the purposes of contact tracing. Now, that's going to vary in whichever local area you are, but normally it'll be a person's name, their contact telephone number, and the date and time that they attended. Where there's a group, hopefully of under 6 or at 6, collecting the details of the lead member will normally be sufficient. You've got to tell customers what data they're collecting and why. by providing a privacy notice in a publicly available space. You've got to inform customers what information they're collecting, why you're collecting it, and how long it will be used, stored for. For example, who you're going to share it with, how long it'll be held. That information is then to be kept securely. Any physical list should be locked away when not in use, and any devices which store the information should be password protected and ideally encrypted. That information should then only be used for the purposes for which it was collected, that is contact tracing, and whilst it might be tempted to use the information as a customer database for promotional purposes, that will not amount to lawful processing of the data, and businesses may be exposed to claims for breach of the GDPR if data is used in this way. Finally, should only keep the information for as long as is necessary. Again, that will be subject to the guidance provided in each area, but the general provision is to retain information for 21 days. And once that period is expired, dispose of the information securely by shredding papers or permanently deleting digital files. Now, I'm conscious of the time, so can we just move quickly on to pavement licensing? Thank you. So permission for the provision of refreshment facilities on a public highway is not a new concept, but under the Highways Act, the process was relatively lengthy. For example, there was a 28-day consultation period. And recognising that there's a need to support businesses to operate outdoors, to maximise safe capacity and to capitalise on the lower risk of transmission in outdoor areas, sections 1 to 10 of the Business and Planning Act 2020 make provision for a new pavement licence. What a pavement licence does is it will authorise the holder to put removable furniture on the public highway for the reasons that are set out on screen. Essentially, what the licence means is that cafes, bars, restaurants can use a pavement licence to offer services al fresco to customers who would otherwise be consuming food or drink inside. Moving over to the next slide, local authorities are going to be required to act relatively swiftly in response to this new licence. They need to adopt electronic application forms, decide on an appropriate fee of no more than £100. They've got to undertake a public consultation of 7 days, beginning the day after the receipt of the application, and then they've got to formally determine or reject the application after the consultation period has ended. Where a local authority does not make a determination within the 7-day determination period following the 7-day consultation period, the licence will be deemed to have been automatically granted. Finally, just on pavement licensing, over to the next slide, please. In the event that the conditions of a licence are breached, an authority may revoke the licence, serve a notice to require taking of steps required to remedy the breaches within a specified time. If as a result of the licence there's a risk to public safety, nuisance or obstruction of the highway is caused, the licence may be revoked. And in that context, the biggest issue is likely to be public safety and customers acting within government guidelines regarding social distancing. For local authorities, therefore, when you're imposing conditions on pavement licences, it seems prudent to impose a condition requiring that tables are located a metre or more apart, and that guests sitting outside are required to ensure that they're wearing a mask if they need to attend inside the property for any reason. A pavement licence will be granted, or must be granted, for a minimum of 3 months, and all of them will automatically lapse on the 30th of September 2021. And just dealing finally and very swiftly with the issue of late night refreshment over the next slide. I'm not going to go into this with in any great detail, I'm conscious of the time. It's just a flag that if a business is thinking of diversifying to provide hot food, hot drink between the hours of 11 PM and 5 AM, an additional licence for late night refreshment will be required. Thank you very much. I'm going to hand over to Olivia now, who I think is going to talk to you about off sales, outdoor events, and crucially, the impact that the coronavirus is having on the grouse hunting industry. Thank you very much.
Good afternoon, everybody. So there's a lot of information on my slides, but they will be available on the website afterwards. So don't worry, the information will be there when you want to refer to it afterwards. So off sales, Section 11 of the Business and Planning Act 2020 has amended the Licensing Act until the 30th of September 2021 to treat premises licenses as if they authorised off sales, as long as they're made at a pre-cut-off time when the licensed premises are open for the purposes of selling alcohol for consumption on the premises. Obviously, that cut-off time is affected by the 10 PM curfew, and the new tier system, but in a world in which the tier system didn't exist, that cut-off time would be 10 PM. Excluded from this change are licensees who've had an off-sales application refused or excluded or varied by review in the last 3 years. Also excluded are organisations with club premises certificates who have to make a separate application. It's not compulsory to tell the council if you want to make use of this amendment, but it's a good idea to do so because then the licensing authority is aware of all the ways that you are engaging in licensable activities. Next slide, please. The provisions also apply the conditions that I've set out on this slide to pre-existing off-sales permissions in terms of matching off-sales hours to on-sales hours, allowing sales in open containers, and allowing deliveries of alcohol. There's a new summary review process as well in the amended legislation, which is the necessary safeguard because the permission has not been considered by responsible authorities before being granted. The salient difference between this new summary review process and the existing summary review process is that this process doesn't require a senior police officer to have certified that, in their view, the premises are associated with serious crime or disorder. Next slide, please. Given the lower threshold for the new summary review process, it's especially important that licensees consider what they can do to prevent ASB or nuisance on the part of their off-sales customers. The guidance that the government has issued as part of this amendment is clear that licensees may be held to account if misbehaviour by customers was reasonably foreseeable. That's particularly relevant in areas where there is a public space protection order in force nearby, and so licensees should consider what soft action they can take to encourage good behaviour on the part of their customers. The example I've given in the slide is posters. An example given in the guidance of what might constitute reasonably foreseeable misbehaviour is selling alcohol to street drinkers who have been associated with antisocial behaviour in the neighbourhood. If you're a licensee and you want the permanent ability to make off sales, then there's no reason to wait until the 30th of September 2021 to make an application, and make an application as soon as possible if that's something that seems attractive. Next slide, please. And I've set out on that slide the link to the guidance document that relates to the temporary licensing provisions. It's actually a very helpful document, so I really, really recommend reading it if this is something that you are concerned with. Next slide, please. And now I turn to outdoor events, and this is where things get much hazier, and unfortunately, as is so often the case these days, my slides have been overtaken by the news. But at least as of yesterday, this information was accurate. In Tier 1, which is what I've set out on these slides, there are two legal routes to organising outdoor events. The first is an outdoor event organised by a business, charity or public body in a public outdoor place where a thorough risk assessment has been carried out and reasonable steps have been taken to mitigate the risk of viral transmission in line with COVID secure guidance. And the second, next slide please, is what I have termed the grouse shooting exemption, which is basically exactly the same as the first route, but it applies in either a public or private outdoor space and relates to a relevant outdoor activity, which the definition I have set out on the slide, but seems suspiciously like it relates to owning guns. Next slide, please. So the COVID secure guidance that you must have had regard to organise an outdoor event under the legislation for performing arts is, as I've set out on the slide. And I've set out 3 examples there of the guidance given. The first 2 are fairly specific and helpful. The third is hazier and demonstrates the difficulty that event organisers are going to have with exercising their judgment as to what constitutes a risk of transmission. Next slide, please. And the second piece of COVID secure guidance is the elite sport guidance, which again, unfortunately, has been overtaken by current events, but is probably still worth having a look at to give an idea of the kind of framework that might eventually apply when it's safe enough for spectators to return to sport. Next slide, please. So if you are brave enough in the current climate to try and organise an outdoor event, how is the Licensing Act likely to apply? Well, the 2 licensing objectives that you really need to have regard to will be public safety and public nuisance. A couple of weeks ago, for example, Birmingham City Council Licensing Subcommittee revoked a bar's licence by reference to these two licensing objectives because of repeated infringements of the COVID regulations. And finally, next slide, please. To end on a low note, councils currently have the power to refuse permission for an event in accordance with the regulations set out on this slide, where they think there is a serious and imminent risk to public health because of the potential for the spread of COVID. That's something of a whistle-stop tour, and I will hand you over to Matt to talk about novel forms of licensing.
Thanks very much, Olivia. That was great. I just had a bit of a wobble with the slides, but I've hopefully got it sorted out now. So I think in many ways this feels like a real moment of transition for the licensed trade. The summer is definitely over. The fine weather is gone. The Eat Out to Help Out schemes run out. The furlough scheme comes to an end, I think, at the end of this month. And now we're in the grip of a second wave of the virus, and the licensed trade is obviously particularly vulnerable. For almost a month, all licensed premises in England have been ordered to shut at 10 p.m. Nightclubs have remained completely shut for 7 months, almost. Last week, the Scottish Government ordered all licensed premises in Edinburgh, Glasgow and the Central Belt to shut altogether. And now the new tiered restrictions that came in yesterday contain further restrictions on licensed premises. So with large parts of the trade facing an existential crisis, it makes the controversy that a lot of Cornerstone members were involved in a few years ago over the closure of fabric seem like pretty small beer. And the club's campaign to reopen, to overturn the revocation decision under the catchy hashtag Save Culture seems particularly prescient. But where there's a crisis, there's also opportunity. Opportunity for Fatima to retrain in cyber, and perhaps with the right kind of government backing, she could go on to set up a multi-jurisdictional drug empire on the dark web. As for me, well, let's hope that you keep sending work into Chambers, because it doesn't look like I've got much else in prospect. On a more serious note though, there was some promising news this week. On Tuesday, a significant amount of cultural venues were given a pretty decent chunk of money from the Arts Council's Culture Recovery Fund. But it is clear now, as Joe hinted or alluded to at the beginning of the session, that we're going to be living with this virus in the community for some time. And so venues are going to have to get creative in order to keep their doors open. But at the end of the day, the public wants to be entertained, and I think that's what cities and towns are all about. So the purpose of this brief talk, is to think of some possible answers to this question: how will the licensed trade evolve? But I'm not going to provide a simple answer to that question. We're going to play Should I License That? Now, if you remember watching this game show on the late Saturday night slot on Channel 4 about 15 years ago, you'll remember how to play, but you'll be glad that I've taken the nudity out of this version of the game. It is 2 o'clock in the afternoon. Now, it's not easy to encourage really any audience participation over Zoom, but you do have the raise your hand function. And if you feel like the answer is an upturned Stein, that it should be licensed, then put your hand up. And then remember to take it down for the next question. Okay, so we're going to start with drive-in cinemas, an old format with great potential for social distancing. It's already proved popular in many parts of the country and has real potential for the colder months as well. And perhaps some of the people watching have licensed one of these already. So, do I license it? We haven't had an exactly resounding response on the raise your hand function, but that's not to worry. Exhibition of a film, if you know your way around Schedule 1 to the Licensing Act, you'll know that that's regulated entertainment. So the answer, of course, is it's licensed. All right, if you put your hand up, remember to put it down, because we're now going to look at street food markets. Now, again, these will be familiar with you to you already. I'd imagine most people will have visited one, perhaps even licensed one. They've been with us, as the image suggests, for centuries. Craft beers, dirty burgers, huddled around burning braziers like hipsters on a picket line. The question is, does it require a license? Well, if you've got your hand up, you're correct. The sale of alcohol, obviously essential to this and potentially most business models. Now, for the purposes of the questions, I'm assuming that there isn't an alcohol element to be licensed. We're just focusing on the activity itself. We've got the sale of alcohol. We've got late night refreshment. It's licensed. But of course, in the COVID era, even the relatively recent innovation of street food markets have been souped up. You only need to look to Manchester, the Escape to Freight Island venue. They describe themselves as a permanent urban market, an axis of food, drink, music, immersive entertainment, festival takeovers, and family-focused happenings. So potentially a lot more being offered than just food and drink. Okay, next one. Escape rooms. How many people have had a go in an escape room over the last couple of years? Now, these have really exploded in popularity. I think introduced to London in about 2012, and they've spread pretty far and wide from there. I've even done one over Zoom recently. Now, by definition, group sizes are limited, so it could make for an ideal hour of entertainment without breaking the rule of 6. Question, of course, is, should we license it? Well, the advanced versions might incorporate an element of film, but it's probably something you can safely rule out as incidental. There's usually no performance as such, even if you've got someone, which you normally do, overseeing the game, perhaps in character. Again, I don't think that's the main part of the game, so I'm going to say not licensed. But if you've got a different view, I'd be interested to hear it. And if you have licensed one, I'd also be interested. On a related note, immersive events. Again, something that's really exploded in popularity, much the same as escape rooms in the last few years. The Crystal Maze, Great Gatsby, even the Wolf of Wall Street have all been given the immersive makeover. Now, you could imagine nightclubs and other venues that have sadly been left vacant as a result of the economic crisis could easily, in some cases, be repurposed into an immersive venue. Do you license it? Well, very often you'll have people in character, actors, so arguably the performance of a play is involved. And again, pre-film segments, exhibition of film, it's part and parcel of the event. So I'm going to say this one is licensed. What about axe throwing? Now, I have to say I was a little bit surprised to discover a year or two ago that some licensing authorities have been persuaded to authorize an event that involved alcohol and throwing bladed weapons. But I'm really pleased that they were open-minded enough to do that. And I think it gives the lie to the accusation that's often thrown at licensing authorities that they're a bunch of killjoys. And having done one for myself, and that was on a stag do in Bristol in January, and lived to tell the tale, and proof itself that these kinds of events can be run safely. Proof, crucially, I think in the COVID context, that we can trust the licensed trade to look after their customers. Is it licensed? Well, arguably it's an indoor sporting event. It takes place indoors, obviously. Spectators are present, kind of loose sense. Other people watching while the game goes on. And it involves physical skill. Physical skill is obviously a very important aspect of being able to throw an axe accurately. And there's an element of competition as well. If you've done it, you'll know. So arguably it's an indoor sporting event. The audience is relatively small. In most cases, I'd be surprised if anyone could encourage an audience of more than 1,000 to attend an axe throwing event. So I'm going to say it's not licensed, but only between 8 o'clock and 11 o'clock, because indoor sporting events are exempt from being licensed between those hours. So if it's a late night operation, then potentially it could be licensed. What about exercise raves? Now, these seem to be a big thing about 5 or 6 years ago. The scene seems to have gone a little bit quiet, but a bit like with immersive experiences, there does seem to be scope for turning over nightclubs, and many of the exercise raves that I've come across already taking place in nightclubs, taking advantage of the nightclub's facilities, could be something that the space could be used for profitably. Potentially ideal for social distancing purposes, no alcohol involved, and you could even provide each person participating with their own space. So all of the things that have contributed to nightclubs being closed for all this time are dealt with. Recorded music, it's not going to be incidental. The exercise rave can't really go ahead without music. It's an essential aspect of the business model. Performance of a dance, you possibly have an instructor performing for the audience. So I'm going to say this one is going to be licensed, but obviously some exemptions to this, as you'll know. The first one is that recorded music doesn't require a license if it's taking place between 8 o'clock and 11 o'clock on a venue that's already authorized to sell alcohol. And performance of a dance, again, doesn't need licensing if it's between those hours and no more than 500 people on the premises. But remember that a lot of these exercise raves take place before work, so potentially before the 8 o'clock cutoff, so could be licensable. Here's our friend the golden retriever enjoying a silent disco. He's the only one, I think. It's definitely an activity that's fun for no one except for those people involved. Again, could be good for the COVID era. No loud music involved. In fact, that's written into the legislation. 85 decibels now is the absolute maximum sound level in licensed premises. So that's great. You can talk without having to shout at one another. But on the other hand, there's no loud music, so you can hear everybody sing. Does it require a license? Well, again, recorded music is pretty essential to this model. I've seen something that resembles a dance going on, so potentially, particularly if you've got someone encouraging the audience, could be an activity that's similar to a dance, so it could be regulated entertainment in that sense. One question though is, what about roving silent discos that take place out on the street? Well, obviously premises license attaches to premises. A premises is defined in the Act as any place. I'm not really sure that that covers something that moves about on a peripatetic basis on the street. So arguably an outdoor silent disco that's not attached to particular premises is not licensable. So I'm going to say this one could be licensed. Finally, in this wonderful game, esports arcades. Now, esports is a really thriving area, but for many people it might have totally passed under your radar, but it's now a multi-billion-dollar industry and attracts a following as big and as avid in some cases as conventional sports. Question is a premises that's hosting esports, consoles, games and activities, does that require a license? Well, I wondered for a while whether that might be construed as an indoor sporting event. But remember that the definition of sport in the Act is that requires physical skill to be the predominant factor in the activity. Now, it might be a workout for your thumbs, but probably not much more than that. So I'm going to say not licensed. Okay, that's all from me. I'm now going to hand over to, have I got this right? Joe and Christina.
It is right, but it's Christina rather than Joe to begin with. Can I just while Christina comes online, just thank everybody for pointing out that you couldn't raise your hands. So I hope you were all doing it actually, physically raising your hands. We couldn't see it, but we had accidentally disabled that function as a trick for Matt. So thank you for everybody who brought that to our attention, and sorry. Christina, over to you.
Thank you, Joe. Thanks, Matt, and good afternoon, everybody from me as well. I will be covering the first part of this topic, which essentially discusses what you can and ought to do prior to a remote licensing hearing taking place, and Joe will then talk about the hearing itself. The very first slide, I don't think this is anything that is particularly new to anybody who's watching this, but in case it is, I just set out the legislative and the regulatory framework for you there, and I just wanted to highlight as well that the ADSO has very helpful guidance on its website, specifically on the latest regulations that came in earlier this year. Going to the next slide, please. There are three things that I will be focusing on, three themes rather. I will talk to you about rules of procedure and what happens if you cannot follow them in the way that you ought to because of the challenging circumstances that we find ourselves in. I will talk to you about the importance of having designated, or the option rather, and the the potential advantages of having protocols, designated COVID protocols in place. And then finally, I will also say a few things about what you cannot do, despite the fact that we are in a pandemic situation. Moving on then to the next slide, please. I think it's one more. Yeah, so as far as complying with the regulations is concerned, the key takeaway point here is really that you should, obviously, as best as you can, aim to comply with specific requirements, such as the method of advertisement. However, where that is not feasible, you should aim to use the best practicable method instead. The key point is that procedural defects will not automatically invalidate a licensing determination, and I've noted a few case law authorities here that you may wish to look at on that point. The key question you want to be asking yourself is whether the lack of compliance or the slight deviation perhaps from the rules has caused any prejudice, and if there is such a prejudice, whether there is a step that you can take to cure that resulting prejudice. Next slide, please. Thank you. So the next point is essentially the third bubble that I had on my opening slide, which is that there is no lawful power, even during these times and with the special regulatory framework that is in place, for licensing authorities to delegate decision-making to offices where representations have been received. So this is still very much something that will have to be determined by a subcommittee. And then the third point, which, if I'm not mistaken, was the second bubble on the opening slide. Sorry, I'm still on, yeah, thank you, Matt. The third point is that you should promote virtual hearings as the new normal or the new reality on your website, and make it clear to members of the public that online applications are your default method, and that you wish to receive, if possible, representations online as well. So rather than having a piecemeal approach, to have a holistic, so to speak, strategy for licensing hearings. And one way of doing that in a very transparent and organized way, in my view, and this is the next slide, is to have a special protocol in place. Now, I've seen online that some local authorities already have these types of protocols on their websites, others don't. Essentially what this is a protocol on licensing hearings in the COVID era, where you set out what the public can expect. You set out the different measures that you have taken, and it essentially informs potential participants as to what the new reality looks like. Obviously, ideally, notify people as early as possible about the hearing taking place remotely, and make sure that all of the relevant documents are available online as well. I will finish with two final tips on my last slide. The first is that, again, to streamline things and to tick all the right transparency and fairness boxes, I would recommend that you encourage parties to submit by email written submissions at least 24 hours before the hearing is due to start. This will help with the effective and efficient running of the hearing itself. And then secondly and finally, to remind parties that where an application has attracted representations, that does not necessarily mean that the hearing actually needs to go ahead. This can be dispensed with where all the parties have given their consent. However, if the hearing does go ahead, there are a few things to keep in mind as well, and this is where I hand over to Joe. Thank you.
Thanks very much, Christina. Yeah, in the same vein, really, just looking at the practicalities of running these hearings. Now, I imagine, where are we, October, we've been going almost 6 months. I imagine most of you who are tuning in have either attended a virtual hearing or run one if you're from a local authority, but just a few tips really on how to do that best. Just a couple of points about adjournment. So at the beginning of lockdown, there was some suggestion that licensing authorities could just kind of kick licensing hearings off into the long grass because coronavirus. Well, they could certainly be adjourned, but not indefinitely. The hearings regs, not the flexibility regs, but the original Licensing Act hearing regs do obviously permit for adjourning hearings, but not for an indefinite period. They have to be adjourned to a specified date. That's Regulation 12. The letter from the Minister Kit Malthouse, that's the second bullet point there, basically made clear that coronavirus was not a reason to adjourn hearings generally, and that hearings should proceed where possible, and that was why they enacted the flexibility regs. And those regs also, again, this is sort of old news really, put to bed an old discussion about whether you could have a hearing in public, which is of course what's required by the Act and the regs, and also remote. So could it, if it was by Zoom or Teams, could that also be in public? Well, the flexibility regulations makes that absolutely clear that it can be, even if there was any question beforehand, and I think everybody agrees now that it could have been beforehand too. So that's really some old news. The real question is, how do you manage these hearings to make them fair and effective? And that's the next slide. One thing that comes up often is, both in remote hearings and in live events, is the rule that there should be no cross-examination. As you will all know, I think, a licensing subcommittee hearing should be a discussion led by the chairman, whatever that means, and that cross-examination isn't allowed unless it's required, and it's at the discretion of the chair. My view is that, well, my general view is that cross-examination is very rarely helpful in a licensing hearing. It kind of elevates it to a level of formality that doesn't help anyone. But it seems to me that it's even less likely to be appropriate in a virtual hearing where you aren't face-to-face, it's much harder to control, and so on and so forth. So my tips, having done a few of these remote hearings, is that, both as legal advisor and a participant, is that if you're thinking about asking questions, ask yourself whether those questions might really be better made by submission. Aren't you really just making a point? In which case, save them for submissions. However good these platforms are, Zoom, Teams, so on, there is always a bit of a time lag. If two people are speaking at once, then you can't hear either of them. And the kind of cut and thrust of question and answer doesn't really work, in my view. So if you can avoid asking them as questions, instead make them as submissions, my view is that that's much more effective. And I think chairs should say that at the beginning of a hearing. And then obviously you need to, if you're running one of these hearings, you need to work out a mechanism for getting attention. Whether you're a participant or one of the panel or whatever, you can't see everybody else in the hearing, so you can't see that someone's itching to say, oh, hang on a minute, you've got that wrong, or I can't hear, or something. The hand up function in Zoom, when we remember to activate it, is quite a helpful one. But you need to have some kind of mechanism. I had a hearing last week, actually. In fact, Martin Clark from East Suffolk is here and was in that hearing, where one of the advocates was summing up. I was the legal advisor, and another party couldn't hear and was trying to tell us, couldn't tell us. We couldn't either hear him or see him. And in the end, the advocate had to redo all his summing up. So he said it twice, which wasn't ideal, but it was the only way to deal with it. So there needs to be some kind of mechanism. What about excluding people from the hearing? Not something that you want to be doing very often generally, but sometimes it's necessary. There are two powers to do that. First of all, where it's in the public interest, and this usually comes up where you're talking about information that might be part of a police investigation and therefore not for general consumption by the public. That's Reg 14 of the general regs. And then the second power is where somebody is being disruptive. That's Regulation 25. You might want to get them out because they're stopping the hearing going ahead. In the kind of Zoom, remote, Teams, whatever era, how do you do that? Well, on the public interest test, so the Reg 14 power, consider whether a breakout room or ending the meeting or a separate channel might be a way of excluding the public. In that case, you might have to end the meeting, start a new meeting. Zoom has a very helpful breakout rooms function, which I've used in licensing hearings, which means that the subcommittee plus legal advisor plus whoever can be privately in a room, and that information could then be heard. Disruptive people, again, you could just boot them out, but then they could just come back in. So there needs to be some kind of mechanism, if you're running one of these hearings, to keep a removed person removed, as it were, so you don't have to keep booting them. Just a reminder that Regulation 25 says that if you do boot someone out under this power and they want to make their points in writing, then you must allow them to do that. That's Regulation 25 of the hearings regs, not the flexibility regs. Okay, next slide, please, Matt. There we go. Deliberations and the decision. So you've got to the end of a hearing. How do you deal with this? I've seen a couple of ways of doing this. Generally, in licensing, you deliberate in private unless you're Camden. We could have a whole seminar on whether that's a sensible idea or not, or I could just use one word about whether that's sensible. The best way I've seen this done is just to end the meeting at the end of the evidence, and then the subcommittee plus licensing officer, if necessary, plus legal advisor meet in a separate private meeting and do the deliberations. But you can also enter a breakout room in Zoom and keep people hanging on, or tell people that you'll be back in an hour and a half or whatever. The law says that you must make the determination within 5 working days of the hearing. No requirement to announce the result on the day or at the end of the hearing. You've got 5 working days. And in my view, you should use that time, if you're a local authority, in the Zoom era, or the other platforms are available era, use those 5 working days, deliberate, come up with a written decision and send it out to the parties. It's difficult to keep people hanging around on these platforms with no sense of when you might come back. It does allow for a bit of flexibility about when you deliberate and so on. What I have seen done is a short deliberation period where a decision is reached, sort of yes or no on the application. That's announced, reasons to follow. Appeal time doesn't start to run until the reasons have been sent in the post. So again, that's quite an effective, or can be quite an effective way of doing things. So just moving on then to a couple of practical tips. Again, I think this is probably old news for most people. First of all, you will need to decide on a platform. I've obviously used reference to Zoom and Teams, but there are other platforms available. My experience is those are the 2 that work the best. Even the court has now stopped using Skype for Business, I think. And of course, you also need to make the meeting open to the public, and the best way to do that is to webcast it. People are doing that on YouTube, and so on and so forth. So all that needs to be stable and needs to be set. And then next slide, I think last slide for me. Just a few tips, really, in preparation, and Christina's really touched on this. If you've got a protocol for running these hearings, and you should have one, as she says, then make sure that all the participants get it, send it out well in advance. Take some time at the start of a virtual meeting, a bit more time than you might in an in-person event, to identify who everybody is, make sure that everyone's comfortable with the protocol, understands the technology, knows when and how they're going to speak. There's also, it seems to me, a lot of justification for asking for a speaking note to be handed in advance, written evidence and submissions. There's already a rule, as Christina says, that it has to be before the hearing. I think there's definitely an argument for that time being extended, so not just the day before, but if you can do it, I know one authority at least says 3 days before. I think that makes sense if participants can do that. Just a few little points about security. You do have to control permissions. What you really don't want is all the attendees to have access to the chat, so that when you're saying, oh, this guy's got a funny moustache, or is that a picture of his father behind him, or whatever, don't they look similar, that the whole meeting doesn't get to see that, only you get to see it. In terms of inviting participants, people are going to be speaking, use email rather than a general posting of the link on the website, because that, again, could get difficult. And really importantly, have a contingency plan for the example that I gave you a moment ago, somebody being a participant being unable to hear what was being said. And in our case, they were unable to hear the summing up of the person who was kind of against them. So that was obviously unfair, because they were then going to have to respond. So we had to kind of go back and do it again. It was a bit unsatisfactory. We got round it, but he managed to alert the regulatory services officer or whoever it was that he couldn't hear, and we got back in. But you probably need to provide a phone number or some way of contacting or alerting the meeting if somebody is unable to participate or becomes unable for all sorts of potential technological reasons. So again, this is all really coming to the same point, which is these meetings work perfectly well remotely, but they need a bit of advanced planning. You need to think about it in advance, and sometimes you need to be a bit more careful about the protocol and the planning of things than you would with a live event. I think that's all I wanted to say. Next up is Kuljit, who's going to talk about enforcing public health restrictions. Do keep your questions coming. We're not ignoring them. We've got a list of them. We're going to deal with them at the end if we possibly can. Thanks very much.
Thank you very much, Joe, for that handover. As Joe said, I'm going to be talking about some of the powers that are available to local authorities in relation to creating local restrictions. So these are different to the national restrictions or the tier 1, tier 2 type restrictions that the government have announced earlier this week, but they relate to the powers of local authorities to be able to impose restrictions to close premises or to restrict access to them. And so in looking at the first slide in relation to this presentation, if Matt could move it on to the next slide, please. There are four main sources of powers in relation to controlling premises and closing down premises. I'm going to be talking about the first three of those, and we'll speak in a bit more detail about each of those. And it's worth knowing that I've recently used the Public Health Control of Disease Act to close a shopping centre partially. And the context was a long-standing problem of rough sleepers gathering in the shopping centre overnight. There were some 160 units within the shopping centre, and because it was a right-of-way, it had to be kept open overnight. And there was some discussion about using a PSPO that had been rumbling along, and when COVID happened, the issue became one of health and public safety, partly because the rough sleepers weren't practising social distancing, and partly because the owners of the shopping centre weren't able to clean and ensure that, that there was the thorough cleaning that was required overnight prior to the shopping centre coming into use the next day. And initially what the local authority had done was apply for a closure, a 28-day closure under the 2010 regulations, the control of disease regulations. And it's a lot of work, and once it was discovered that they were having to keep going back every 28 days because this was going on for longer than anyone had anticipated, we then looked at using other powers, and that's when we sought to ask the Magistrates Court to impose a closure order in respect of the shopping centre with very similar terms to allow continued opening during the day and a closure overnight. And it meant that we could go back to court every 3 months for a maximum of 6 months under the closure powers of the 2014 Act. And then if we need to, we may need to go back again to obtain a further period of closure. But it's quite a useful example of how, although we've got these individual powers, it is worth looking at the broader picture and the whole suite of powers available to you, and to how they might interact with one another and be used both on their own, but also in conjunction with other powers. So if Matt could move on to the next slide. In relation to the Public Health Control of Disease Act, I've set out some information on the slide. I'm not going to go into too much detail. It's there for you to read, and you'll be emailed a copy of these slides afterwards. And indeed, there'll be a recording of the whole webinar on our website afterwards. As I've said, that the power is available for a maximum of 28 days, and it's likely that for those of you that are local authorities, you will look to apply, or rather liaise with your public health officers in terms of justifying the need for closure of premises. But it does allow you to close them in the type of example that I've given, where there's an infection or contamination or a significant risk of harm to human health. So it's worth knowing that there's this 28-day closure power available under the Control of Disease Act regulations, and these are pre-COVID, so these have existed for a while and aren't a specific response to the current problems. But on the next slide, we have some information in relation to some of the measures that have been introduced specifically in relation to COVID. And I'm going to spend a bit of time on these because these are what's new since we've been in this state of lockdown and then restrictions. And these are the Health Protection Coronavirus Restrictions England #3 Regulations 2020. And for any of you who have looked on Westlaw or some of the other sources for regulations, you'll see that there are now a very large number of coronavirus related regulations that seem to be changing on a regular basis. As at this morning, these regulations were still in force. They automatically lapse in the way that a number of the coronavirus specific regulations have been designed. And the powers are exercisable by upper tier local authorities. And I've put on the slide who those are and where you can find out more information as to the specific definition. Importantly, for those of you that are local authorities, but also for those of you that might be on the receiving end of the use of these powers, they are broad-ranging powers and they allow local authorities to restrict access to premises, to close them completely, to prohibit certain events from taking place or certain types or categories of events from taking place, and then to place restrictions on outdoor public spaces. And as I say, these are local powers exercisable by local authorities in addition to the national or area-wide restrictions that they might be imposed by national, at a national level by government. So they are broad-ranging and powerful. And to look at them in a bit more detail, on the next slide, I've got some information in relation to the conditions that need to be met in order for local authorities to exercise these powers. And these conditions are common to whether it's a restriction of access or a closure of access, and whether it's indoor or outdoor. And you'll see there it's that the local authority have to be satisfied that the powers are being exercised in response to a serious or imminent threat to public health. And I think it's pretty clear that we're in that territory, and that they're necessary for the purposes of preventing or controlling or providing a public health response to an incident or the spread of COVID in your local area. And they've got to impose restrictions that are proportionate, and you'll see that it's not only prohibitions but requirements that they can impose. So a requirement to take positive steps as opposed to being limited simply to not to do certain things. You'll see there that if the local authority decide to use these powers, they have to notify the Secretary of State, and then any restrictions that are imposed have to be reviewed every 7 days. On the next slide, I've got some information in relation to the specific powers to close premises or to restrict access. And for those of you that want to find out more, those powers are found in Regulation 4 of the regulations. And they can be imposed on owners, occupiers, or anybody else involved in managing entry or departure from premises. And as I said there on the slide, some of the things that can be done are to restrict the numbers of people, the purpose for which premises are put into use, and also the facilities that are in place in relation to those premises. There are some exceptions, one of which I've summarised there, but there are others, and it's worth looking at the regulations in more detail if you're interested in the accepted categories. But as I say, they are broad-ranging powers that apply to most premises. On the next slide, I've got some information in relation to restricting what happens in relation to events, and this is Regulation 5 of the regulations. And it allows a local authority to impose restrictions on the owner or occupier of premises or any other person involved in holding an event. So if somebody's hiring those premises with a view to using them for a particular purpose, the restrictions can be imposed on that person as well as the owner or occupier. It can include an information requirement in terms of notifying people attending the event of the restrictions. And there is the regulations make clear that anybody whose only involvement is attending and nothing beyond attending is not a person that would be considered any other person involved in holding an event. But apart from that limitation, as you'll see, any other person is quite a broad way of defining the people that are involved in those events. So those are the powers for events. And then the last slide in relation to the particular powers is Regulation 6 for outdoor public spaces. And I've put there what those powers are and the right to appeal in relation to those. I'm going to move on to enforcement and offences, which is on the next slide, just because I'm conscious that we're running short on time and John's still to speak. I've put the details there as to where the powers are for enforcement of the any restrictions that are put in place. And this is the source of the stuff that's hit the news in terms of the large fines that are able to be levied in relation to restrictions. And you'll see it's Regulation 14 that imposes the ability to issue FPNs, and that for each repeat offence, at the sixth offence point, you're able to fine an amount of £3,200, and it can be that for each subsequent offence. So worth bearing in mind that they do have some teeth in terms of the enforceability of these powers. I want to look very quickly, if I may, before I hand over to John, to the next slide, which deals with some of the powers that are available to you under the Antisocial Behaviour, Crime and Policing Act of 2014. I have put on this slide, and as I've said, you'll get copies of these, some links to videos that I've already done in relation to community protection notices and closure powers. And whilst I will say a bit about them now, if you want to find out a bit more information about how these powers can be used, there's information already on the website. As Joe mentioned, there are quite a lot of resources on there. It's worth having a little dig around. But specifically in relation to CPNs, on the next slide, I've got a list of the sorts of things they've been used for, and you'll see that there is a whole host of things that CPNs could potentially be used for. The range of those activities is so broad, it's impossible to give you a complete comprehensive list, but you can well see how in relation to some of the breaches of social distancing, there is scope for using these powers as long as the statutory test is met. And on the next slide, I've given you an outline of what that statutory test is. So you'll see there that the key phrase is that you need to be satisfied as a local authority or as a police officer, and it's local authorities and police that have got these powers, although there is a power to designate housing providers to issue CPNs. That hasn't really, it's happened in a few areas but not happened in many. So the local authority or the police officer has to be satisfied that there is a detrimental effect of a persistent or continuing nature on the quality of life of those in the locality. And it's a two-stage process, a warning followed by a notice. And you'll find more information on what detrimental effect means and what persistent and continuing means in the videos that I mentioned earlier. So do have a look at those if you want to find out some more information. And then finally, in relation to 2014 Act powers, it's worth just highlighting the closure power that's available. And for those of you that do areas other than licensing, you'll know that there are not only the old licensing closure power, but also powers related to closing premises involved in drugs and antisocial behaviour have now been consolidated so that there is a single closure power in relation to all types of premises, both commercial and residential, and whether they're licensed or not. So it's a consolidated power available to the police or to the local authority. And for those of you that work in other areas, it's a case of working with your local authority or your police if you're wanting to have this power utilised. And on the next slide, which is the last slide of my presentation, I've set out the test that has to be satisfied. So as I said, we use this for the shopping centre closure in order to get a 3-month period of closure as opposed to having to renew every month. And you'll see it's so what you have to ask yourself is whether the behaviour that you're concerned with fits within that language in order for you to be able to use these powers. And in addition to one of those 3 elements being satisfied, the court has to be satisfied that it's necessary to close the premises for the purposes of preventing further nuisance or disorder. So those are the closure powers. I'm going to hand over to John, who's going to talk to you about safer public transport.
Thank you, Colgit. I'm conscious of the time, and obviously if there are people who need to leave, by all means do. I will hopefully only detain you for a further 5 minutes if you do want to stay. I just want to do something very light touch in respect of what's going on the transport front at the moment, because we know so much has changed in the past few months, and some changes that were coming down the track have actually been sped up by the impetus that has arisen as a result of the pandemic. So when we think about safer transport, what we're thinking about is a move away from public transport like buses, trains and tubes to means of transport that of course are much more easily socially distanced. So it's unfortunate, but we are returning to reliance on the private car, and of course that involves taxis as well. But we're also thinking about things like e-scooters and cycle schemes. And how does this interact with licensing? Well, what we're really thinking about is the future role that potentially licensing might play in respect of all three of these. So first, with taxis, if you're a licensing authority and you haven't done this already, it might be useful to provide some sort of detailed guidance to your drivers and operators in respect of safer transport. One local authority that has done an excellent job in putting together guidance is Rochdale. You can Google their guidance. It's just on their website in the section on licensing. And they set out very clearly social distancing advice for taxi drivers. And it's all the things that you might expect, such as keeping a minimum safe distance from customers, where possible, taking customers who are from the same household, things like before the journey, asking the customer if they have luggage, and if so, how that's going to be dealt with. And then second, on the hygiene and safety front, they have advice about, of course, taking card payments rather than cash payments, having disposable tissues in the cab to ensure that if anyone needs to sneeze, there's something available. And similarly, keeping windows open to ensure ventilation. And I'm sure most people who, if you've taken an Uber or a taxi or any other private hire vehicle in recent weeks or months, you'll have seen that the windows are generally kept open in the back of those cabs. On face coverings, of course, we know these are now mandatory for passengers, not mandatory for transport workers and taxi drivers, but at the same time, of course, they are advised to wear them. But it's also important to remember that taxi drivers should be reminded of the need to remove a face covering when asked by a passenger to do so, if there's any sort of queries about the identity of the taxi driver matching up with their licensed badge. So just do bear that in mind. And then cleaning and waste disposal, what we're thinking about here is advising taxi drivers by way of guidance to clean their vehicle thoroughly with wipes and disinfectant spray, cleaning areas of the vehicle that are touched regularly in particular, any personal waste being stored in disposable rubbish bags, all of those sort of things. And as I say, Rochdale is one of the councils. There's a few councils that have done a very good job on this, but Rochdale has put together detailed guidance for taxi drivers, and I'd recommend it. Moving on then to e-scooters. I told you I'd be quick. We all know, as was just mentioned, that the Business and Planning Act has created the new pavement licenses to be issued by district and London Borough Councils. And so it's not inconceivable that we're going to start seeing similar directions of powers towards local authorities in respect of the policing of e-scooters and bikes, and indeed segways. Now, personally, riding on a Segway is not really my brand, but if it's yours, you do you, and best of luck to you. But in terms of the experiences abroad, we're sort of starting to learn from these, because e-scooters arrived really in Paris in 2018, where I think by the following summer, there were about 20,000 e-scooters on the streets of Paris, with up to 10 e-scooter providers. And they've really been a bit of a menace. So many of them have ended up in the Seine. There's been crashes, fatalities. And so the UK has approached e-scooters with a certain degree of trepidation. But the pandemic, in a sense, has sped up the requirement to get people out on the streets using e-scooters. And so earlier this summer, the Department for Transport introduced the electric scooter trials and traffic signs regulations. And so what we now have are trial schemes in place in various parts of the UK. They've begun in Middlesbrough and Hartlepool. But the problem that we're seeing is that, unfortunately, there's been widespread use of the e-scooters by teenagers, There's been complaints, for example, that 2 teenagers decided it would be fun to take the e-scooters for a spin down the A19, which is of course a road where people go at 70 miles per hour. And similarly, teenagers using e-scooters in shopping centres, to the extent that the Hartlepool MP, Mike Hill, has called e-scooters as useful as a chocolate fire guard. So there's been a lot of difficulties, and in London, TfL are intending to launch the trial scheme next spring. So we're still not quite there yet in London. But what we need to remember is that e-scooters are actually being treated as motor vehicles at the moment. So they're being used on the road and on cycle tracks, but not on pavements. And in fact, it's currently an offence under the Highway Act for them to be on a pavement. So thinking about the role of local authorities and the role that you might have in the future in respect of e-scooters, I think what's going to arise is that you'll be thinking about designating road space as more road space as cycle lanes to ensure there's provision for e-scooters, and in that regard issuing new TROs, but also endeavouring to ensure that pavements are not cluttered in the same way that they have been by the dockless cycle hire schemes that we see throughout London. And that brings me on to cycle hire schemes and how those are being dealt with, if we go to the next slides. So we've seen lots of innovation in the cycle hire scheme area in the last few years. First, just to draw to your attention, there's of course local authority schemes, and I'd encourage you, if you're in a local authority and you don't have a scheme up and running at the moment, to look at Greenwich's, it's called the Easy Cycle Electric Bike Loan Scheme. Really, really efficient. I have friends who live in Greenwich who are using it at the moment and are loving it. Second, there's the cycle London-wide cycle schemes, and indeed these are schemes in other cities as well. We know at the moment there's 5 providers of cycle hire schemes across the city. But the key issue that keeps cropping up that is a concern for local authorities in respect of these cycle schemes is of course the pavements, because we've seen even just outside Chambers on High Holborn here, bikes littering the pavement and causing huge difficulties for blind people, the elderly, and also of course not forgetting people trying to social distance in the current context. And so in light of this, what the London councils have been doing in conjunction with TfL is negotiating to have bylaws to effectively ensure that dockless operators only offer for hire vehicles that are safe, that the vehicles are parked only in parking spaces agreed by TfL and councils, and that the operators share data to monitor compliance. The problem is that these bylaws have been talked about for a good while now, up to 2 years now, and I believe they're coming to fruition, and there's still a few local authorities who haven't inputted into them yet. But in the meantime, local authorities are getting restless, quite rightly, in the situation they're facing. And so some, like Hackney, for example, have taken to introducing their own enforcement policy in relation to these issues, and simply entering contracts with particular operators. So Hackney, for example, have entered a contract with Barrel and Jump to get Barrel and Jump to actually provide over 70 dockless parking spaces across the borough, which means, of course, that you avoid the need for people to park bikes on the pavement, and you avoid the need to sort of worry about enforcement in respect of the pavement as well. So hopefully, in summary, whilst I've broadened away from the topic of pure licensing, I just want to give you a flavour of what's coming down the tracks in respect of e-scooters and cycle schemes, and to let you know what to bear in mind in respect of taxis and taxi guidance going into the future. So I know that was a bit rushed, but I will hand back to Joe because I am conscious that everybody has been online now for about 1 hour and 10 minutes.
Thanks, John. Remarkably, 140 people are clinging on despite the fact that we've been going as long as we have. So we've lost about 10, which I think is a pretty good attrition rate. We're going to try and answer a few of the questions that you've answered, just so that everybody knows how we've been dealing with it. Some of them we've answered in writing. So if you asked a question we might have answered it in writing, in which case it should show up on your screen. But there are a few that we think we might answer live, as it were. Please don't feel any obligation, those of you who haven't asked a question and don't frankly care about the answers to the questions that have been asked, don't worry about leaving. You have our permission and our blessing to leave now if you want to, but if you do want to hear more from these people, then stick around for 5 or 10 minutes. Shall we start? Matt, I think you were going to deal with Andy. Andy Newman. Hi, Andy. He was first out of the blocks with a question. Can a licensing authority refuse to disclose any information to an events company where a review has been taken out against them by residents unless an FOI application is made? Matt, do you want to deal with that?
Yeah, thanks, Joe. Well, I think the helpful way to think about this, and with many questions of a legal nature, is not to think about them as a lawyer at all. Think about them in a common sense way. The answer is clearly yes. It would be grossly unfair to put an events company through a review and not disclose potentially relevant information to them as part of that process. Now, it could be that the company can make an FOI request, but that is very slow and there's no guarantee of an answer. The authority definitely has power to do so. Not specifically in the Licensing Act, but it would definitely be something that is reasonably incidental and certainly conducive to its general licensing function. So I would be relying on Section 111 of the Local Government Act 1972. And clearly, in order to make sure that that process is fair, I think they should be giving disclosure and they shouldn't be forcing the company down the FOI route.
Yeah, I agree with that. Thanks, Matt. That's helpful. Martin Clark from East Suffolk asks, would it be harder to exclude somebody for being disruptive on Zoom as you can just mute them? I think that was a point in response to some of the things I was saying about how you might exclude people. I think the point I was making was that you might put them on mute, but they might unmute themselves. And I'm not sure that it's a default setting in Zoom that if you mute someone, they can't then unmute themselves. So if that's how you want to do it, then that's what you need to set up in advance, and you probably need to make that clear in your protocol. The point I was making was that if you actually boot someone out of the meeting altogether, you need a mechanism for not allowing them back in, as it were. So I think in some ways it is easier to stop them being disruptive. I mean, in a sense, muting them probably deals with the issue. Although, as we've seen from some of the sort of Zoom war stories, not having access to sound doesn't necessarily stop you being disruptive. You can hold up signs, you can take all your clothes off. There's all sorts of things that you can do which would continue to be disruptive even if you were on mute. Yeah, I think there are things about remote hearings that make it harder to do that and things about remote hearings that make it easier. So yeah, that's what I think about that. Thanks, Martin. Kuljit, do you want to deal with Chinelia's question? Although I think you might have done it in writing, is that right?
Yeah, I did put a response in on the written answers, and for those of you that aren't familiar with the function, you can go into the tab which says answered and look at the questions that other people have asked, and also the questions that the answers that members of the team have already put in relation to those topics. So just very briefly, Chinedo asked about whether a CPN could be enforced against somebody who's homeless or rough sleeper of no fixed abode. And the simple position is that it's difficult in the way that many forms of enforcement are difficult in respect of rough sleepers and the homeless. And that's partly why in the shopping centre example, we went down the closure route, because there are criminal offences that attach if somebody breaches a closure order, and it was a partial closure order only effective overnight. And the police have powers, and they go beyond the powers that the local authority have available to them to effect an immediate improvement in the situation. But the reality is that this is a difficulty with anybody that's of no fixed abode or who refuses to provide name and address details. Really, it's only the police that have teeth in terms of powers to deal with that.
Thanks, Kuljit. I think we've just got one more outstanding. We've got a little internal panelists chat. No one's volunteering, so I'm going to jump back in and deal with that. That's Ian Sandwell's question, which is actually one that comes up quite a lot. Public health, he says, is not a licensing objective, which is of course true. It is in Scotland, but not in England and Wales. But can we consider public health objections under any of the other licensing objectives? I think this is probably a COVID question. Can local authorities consider COVID secure setup and so on as part of the licensing objectives? Well, I think the only one really is public safety, and it's arguable at best that that's what the licensing objectives were written in anticipation of. Of course, the reality is that nobody knew COVID was coming. Nobody knew we'd have a requirement to do all this. I think the answer is, yeah, we can consider COVID secure provisions and so on. I think it would have to come under public safety. There's an argument that it might come under crime and disorder too, because some of the requirements carry criminal sanctions if they're not carried through. I think the practical reality is that local authorities will want to hear what kind of COVID restrictions license holders are putting in place, and that might well go to their general credibility and so on and so forth. But I think strictly there isn't a licensing objective that governs COVID security and so on. Does anybody want to add to that before we come to Andy Newman's second question, which Matt's going to deal with, I think? Any other panelists want to add anything to what I've said? Shakes of heads. Matt, over to you.
Thanks, Andy, for the second question and for keeping us busy. I think the answer is that the licensing authority have probably got this one right. The public square, if we've understood this correctly, is not part of the premises, so it's not within the licensable area, and they probably don't have landowners' consent either. So I think that their rights over that square to use for their business are pretty limited, and it's largely going to be a question of negotiation with the landlord, which I think is what's going on if they've been told that they've got to make soup inside the restaurant. It seems to be implicit that they're allowed to use the square. So I hope I've answered that correctly. I don't think in other words, I don't think the pavement licensing provisions help in this situation, because as you've pointed out, it's not a highway.
I think that's right. It's 1:20. We've detained you, I think, for long enough. Thank you, everybody who's submitted questions. We couldn't and didn't promise to answer everything. So if there's anything burning that we didn't answer, feel free to email one of the three practice managers who you can see on the screen, whose emails you can see on the screen, and they will send them on to the panel. Can I just ask, thank you all, first of all, for turning up and listening and sticking with us. Sam, who's running this event, tells me that he will leave the Zoom webinar open for a period after we finish, so you can read through the Q&A, and if there was something in there that you didn't take a note of, you can go back to it. And remember what I said at the beginning, which is that our website, cornerstonebarristers.com, carries quite a lot of really what we think are really helpful resources for both for COVID-related stuff, but also more generally. So thank you very much for attending, particularly to the 112 of you that have stuck around to the bitter end. And we hope to see you all, whether virtually or otherwise, soon. Thanks very much.
Thank you.